Hi guys, it's Kathy. I hope up until now you're doing well, because I don't know how you're going to be doing after now. So the first clip we're going to start with, nothing really crazy happens. Okay, there's an inmate in jail and she's pro se. Gotta love it. All right. So the first part, um, where the judge is talking to her and the lawyer talks, is a bit boring. It just is. It's boring, but it's not. Some of you will see it and you can't unsee it. Some of you won't see anything and you're just going to be bored the whole time. So, yeah, I'll just apologize afterwards. I'm just going to play it.
How are you proceeding, your attorney Sandberg?
Okay. Well, we have the default for failure to appear that was granted as to the non-appearing defendant on February 15th, 2023. Ms. Sonora filed an answer on February 7th, 2023, and Your Honor granted her motion for summary judgment on November 26th, 2023.
Bear with me.
Do you need the docket entry numbers?
Yes, please.
Okay, the default for failure to appear is 115.1.
Where's my order on the summary judgment?
Oh, your order on the summary judgment is 118.2.
Bear with me. All right. All right. I have, Ms. Senor, I have previously granted a motion for summary judgment as to liability in favor of the plaintiff. I am going to proceed today. I will give you the opportunity to be heard on the form of judgment when I get to that point. So, Attorney Sandberg, you've reviewed the defaults with me. Let me again take a look at your exhibits.
Certainly, Your Honor.
Okay. I do recall this case now. All right. You have first is a promissory note. Do you have that note in your possession?
Yes, Your Honor.
And did you have it when you commenced this action?
Yes, Your Honor.
All right. The next exhibit, Plaintiff's Exhibit 2, is the mortgage deed. The deed was given to Morgan Stanley Dean Witter Credit Corporation. Thereafter, there's an assignment of mortgage. From Morgan Stanley to Morgan Stanley Capital Holdings, LLC. Thereafter, Morgan Stanley Mortgage Capital Holdings, LLC assigns to Acacia Federal Savings Bank. Thereafter, Acacia Federal Savings Bank assigns to Morgan Stanley Mortgage Capital Holdings, LLC. Thereafter, Mortgage Stanley Capital Holdings LLC assigns to MERS, Mortgage Electronic Registration Services Systems, Inc. And thereafter, MERS assigns to FV1 Inc. in trust for Morgan Stanley Mortgage Capital Holdings. They are the plaintiff in this action. I will find that they are entitled to proceed to foreclosure. There is an affidavit of debt at 139. Is that the one I should use?
Verifying. Yes, Your Honor.
All right. And this appears to take interest to June 21st, 2024. Is that the one? Is that the finding you request?
Yes, Your Honor.
All right. I will find that as of June 21st, 2024, the plaintiff is due the sum of $221,025.77. There's an oath of appraiser at 140. From this oath of appraiser, I'll find that the subject property has a fair market value of $254,000. The foreclosure worksheet shows that there is some equity, some $32,000 in equity. The United States is not a party. All right. I'll hear from you first, Attorney Sandberg, as to the form of judgment.
I agree, Your Honor, that it is borderline as to sale versus strict. However, recognizing that this is a court of equity and there are subsequent lien holders with an interest in the property, I can certainly see why the court would be inclined to order a sale.
All right. Thank you. Ms. Senor, as you may, what I can explain to you is that the court has to determine whether or not to sell the property through a court auction or allow for a strict foreclosure. With regard to a strict foreclosure, you would be given a date, we call it a law date, by which you have to pay off the bank. If you do not pay off the bank, you lose your legal rights to the property. That doesn't mean you have to leave on that day, but you will no longer have legal rights to the property. If I order a foreclosure by sale, the court would sell the property, and if there are any proceeds over and above the plaintiff's debt, they would then go to subsequent lien holders, and if the sale price satisfies subsequent lien holders and the cost of a sale, whatever would be left would be yours. Right now, the numbers show me that there's $32,000 over and above the plaintiff's debt, but there are some subsequent encumbrances. I'll ask you, do you have a plan or a preference as to how you wish to proceed, Ms. Senor?
I had filed a motion for sale, and it's on the record.
Okay.
For some reason it hasn't come up yet.
Okay, so you wish a sale.
Yeah, but I'd like to pump the brakes here and go back to the original problem, which is that a loan from an unlicensed lender is void upon its making, and it's invalid and unenforceable.
Well, I will tell you that because I previously granted a motion for summary judgment as to liability, I'm not going to consider that argument. So, with regard,
one more thing, there's been no failure to appear. I don't know what they're talking about here. They must have gotten the records mixed up with a different case.
no, we know you've appeared. You filed your answer, and I think the Attorney Sandberg is referring to other defendants. Am I correct on that, Attorney?
Yes, Midland Credit Management is also a defendant in this case, and they have not filed an appearance that I can see.
Yeah. No, I know. We know you've appeared, Ms. Senor.
Okay.
You
So
did.
you're
I
talking-
do. I do see.
Sorry. Yeah.
Bear with me. Bear with me.
Okay.
I do see
Okay.
that you filed a motion for foreclosure by sale that appears on docket entry 142. You indicate that the property is currently on the market?
No, I hadn't gotten that far because I veered off to try to find out what was going on with the fact that they weren't licensed to sell me the mortgage in the first place.
Well,
The property across the street just sold. They had it on the
Oh.
market for 700 and something
Oh,
thousand dollars. Right. I was trying to show what the property values in the neighborhood were. And there's
now
a-
I see what you, I just looked at your motion and now I see where you said that the property across the street is currently on the market. Okay.
Right.
So, listen, it may, if you wanted to attempt to sell the property, then I would consider a strict foreclosure, which means you would have some time to do that. But it wouldn't be a long period of time because it's not like there's a large amount of equity in the property. So again, you filed the motion for foreclosure by sale. So it may be that when the property is sold by the court, it may bring about a higher value than what is being claimed by the plaintiff. As you know, they're saying that the property is worth the amount that's on the foreclosure worksheet, which is
I can't look at it.
$254,000.
I can't look
So
at this
maybe there
guy.
is more value here. So, all right. So again, in view of the fact you filed a motion for foreclosure by sale, and in view of the fact that there is equity, I think I will go with a foreclosure by sale. The earliest sale date we can do is September 28th. Do you want to be heard on that date, Attorney Sandberg?
No, that date is fine with us.
All right. Ms. Senor, do you want to be heard on that date?
We're now at the point where I'm in over my head here. I'm not sure what you're asking.
Well, okay. Well, my point is that the property is going to be sold at a public auction sale conducted by an officer of the court called a committee. And the sale date would be on September 28th. We do these on a Saturday at 12 noon. There'll be a sign placed on your property to advertise this. It'll also be advertised in other formats. The judicial branch has a web page for this. My point is there'll be a public auction of the property, and the earliest date I can do it is September 28th. Which frankly, I'm inclined to do, but I'm giving you the opportunity to be heard if you want to be heard on the date.
Later would be better.
You got to understand, the longer we wait, the more interest accrues and the less, the more the plaintiff gets. So the chances of you getting anything diminish the longer we go out. What date would you propose?
What's the second Saturday of October?
Second Saturday of October is October 12th. Is that date acceptable to you?
Yes. See, again, I'm in over my head here. In the meantime, I still have the right to sell the property through the regular channels, yes?
Yes, you do.
Okay.
And I urge you to obtain counsel also, since you are self-represented. If you sell this property on your own, and you haven't, and there are ways you can, bring that to the attention of the court, and it's possible to stop the sale by the court if, in fact, you do have a bona fide, legitimate purchaser in mind. And frankly, the court would hear you or your counsel on a motion to open the sale date if you had a contract. But I will grant you your request, and I will order a foreclosure by sale and set the sale date for October 12th, 2024. I will award additional attorneys or award attorney's fees to the plaintiff in the amount of $7,895, together with a appraisal fee. What was the amount of this last appraisal, Attorney Sandberg?
Just the last appraisal. Wrong case. Last appraisal, I show the cost is $325.
I will award an appraisal fee of $325, together with a title search fee of $225. Ms. Senor, good luck if you're able to sell this property. Anything more on this matter?
What happened?
Next.
I'm sorry?
I have one more thing that I just wanted to mention. When I spoke to Shellpoint and they were saying that they wanted 30 days to investigate the licensing issue, there's also a matter with a Fair Credit Reporting Act that requires them to investigate within 30 days any dispute. So this puts them in violation of that law.
Well, if the lender chooses to take different action, I'm sure they'll notify their counsel. I'm acting on what's before me today.
Okay.
Anything more?
No, thank you very much.
Thank you. All right, that's that. What's left? What's next?
Next matter is New American Funding LLC versus Teskey.
All right.
And he's gone. I couldn't handle it. I tried so hard. Every time I watched that, I died a little bit. Oh man, that face. I couldn't get past it. Okay. Listen, now that we're happy, and then tomorrow we're going to think of that face and we're going to start giggling out of nowhere. I'll tell you though, some people didn't see it and they're just wondering what the heck they're laughing at. But let's fall in love. Do you want to fall in love with a grumpy old man? Let's fall in love with this grumpy old man. This judge. Man, here we go. I love this judge. I love him.
Let's go back to order and have a seat, everyone. Thank you. Where did Shannon get on to? Yeah, I always look for my court reporter. I've learned to do that because I have started before. Oh, there you are. Okay. I didn't see you that. And I call myself a looking. All right, I need to unmute up here, you say? That one?
Do you want me to help you?
Yes, I do. I want you.
I'm sorry. There you go.
All right, Mr. Roberts, are you with us?
Yes, Your Honor, I'm here.
All right. Now, Ms. Johnson, you're on the next case down, so we'll get to that in just a few minutes, okay?
Okay.
All right. I'm going to call 140-22J25 Timothy Jones, 140-22J26 Viviana Jones, and 140-22J27 the Beta Jones matter. These three cases are on the calendar in the juvenile court of Truton County this morning for a permanency hearing review. Is that correct,
Georgia.
Mr. Butler?
Yes, sir.
All right. Are you ready?
Yes, sir.
Let's see. Mr. Adams, you represent the mother, Miss Megan Jones. Are you ready? And Mr. Devaney, you're here on behalf of the children's father, Mr. Lynn Jones.
Yes, sir.
And I understand from the reports, the case manager's report and the CASA report, that he is in a PDC. Is that your understanding as well?
Yes, sir.
And so he is not present. All right. And Mr. Roberts, who represents the children, is with us this morning by Zoom from Baldwin County. Is that right?
Yes, Your Honor.
All right, let's see. Mr. Butler, let me begin like this. Did you get a copy of the CASA report in this case?
I did, Your Honor. I have no objection.
Mr. Adams, did you get a copy of the CASA report and the case manager's report in this case?
I did, Your Honor.
Okay. Ms. Devaney, did you get those?
Yes, Your Honor, objection.
And Mr. Roberts, did you get a copy of the case manager's report and the CASA report in this case?
I did, Your Honor.
Any objection to them?
No objection.
Of course, as you all know, my policy is if there are questions of the case manager, if the case manager is present in court, and Ms. Townsend and the CASA representatives are present as well. If there are questions, I'll be glad to place them under oath. You can ask any questions you want to ask of the case manager or of the CASA volunteer, Mr. Cobb, I believe, correct? Who is present. All right. Having said that, Mr. Butler, I'm ready whenever you are in the Jones matter.
Well, Your Honor, we do request that the court consider the information in the case manager's report as evidence. In this case, the mother's progress with the father's lack of progress. Excuse me. In the report, it does reflect that Ms. Jones has a place to stay. Beyond that, she has a job, a new job for her. She had resolved one of her criminal cases when at Emmanuel County, and then received a 5-year probation sentence.
Okay.
But she still has the others to deal with.
I'm sorry?
I said she does still have the other counties.
Well, no, let's discuss that just a moment. I know she's got charges in other counties, and these children have been in care since 2022, correct? And it's now 2024, and we're no closer to resolving those than we were back then. Through no fault of the mother's. I mean, she can't go in there and insist that the district attorney of whatever county that these charges are in prosecute it. When we left this the last time, the mother had a hearing date in June, I believe, in Emmanuel County, and I'm other than that, and I did read your report that her employment has not been for 6 months, and the home itself that she's living in, I believe, is with a grandmother, maybe, or grandmother to the children. I'd like to hear a little bit about that situation from someone this morning. All right?
You swear to affirm the testimony you're about to give not only the truth, but the truth, so help you God.
I do.
Up here, please.
For the record, would you state your name and place of employment?
Tamara Jordan with the Department of Family and Children's Services.
So, Your Honor, would you specify again the area that you want her to testify about?
I would just like to know about the home on 3260 Railroad Avenue.
Okay. Ms. Jordan, you've heard the address given, is that where the mother lived?
The agency became aware after hours yesterday that Ms. Jones no longer resided at that address. Her grandmother asked her to leave.
Do you know where her new address is?
This morning, she was going to provide me with that address. She didn't know the address off the top of her head, and she texted the individual to get the address to provide to the agency. We discussed that this morning.
Okay. So you have obviously not been there to look at it, have you?
No, we were notified after hours yesterday. But I had been to the home on 3 occasions The prior residence with the grandmother, we had assessed that household member, her uncle, and we were at the time in agreement with visitation in the home until this transpired yesterday evening after hours.
The prior home was approved for the visitation to occur in that home.
Yes.
And I think you could assess the uncle was in the home and all there may or may not have been, there were no safety issues in that home as far as the actual structure of the home itself.
That's correct. I walked through the home each time I visited.
We'll hear him better in a minute.
2 unannounced visits and 1 announced visit.
And when you are provided with the address, how quickly do you think maybe before you can get there to assess the new home?
Once I'm provided the address, I can go in and assess the home in 2 weeks. Of course, the household members 18 years and older, we have to do a drug screen on them. And I have to talk to that homeowner to see if they're in agreement with their home being assessed. I do know that Ms. Jones have gotten some applications through Housing Authority, through Pine Terrace. She has not turned those applications in because she needs a copy of her birth certificate. She should be getting paid. I think she showed me the check stub, maybe her check post tomorrow. With that check, she's gonna get copies of her birth certificate and turn those applications. She has everything else she needs for those applications.
This home she moved into, she won't be living by herself. That's what you're saying.
That's correct. She's looking for independent housing.
So she was in one house, she moved into another, this is gonna be a temporary? Is that what I'm hearing?
That's what was explained yesterday evening when I became aware that she was no longer at that home. She indicated that she was temporarily residing with someone. Once she receives her pay, she's going to get her birth certificates to turn in. I did have conversations with different housing authority representatives to ensure that her criminal record wouldn't prevent her from getting an apartment. Each one has different criteria and it's a case-by-case basis, but she was advised to put those applications in. She's gonna put one in for Truman Housing Authority, she's gonna put one in for Wrightsville Housing Authority, and she's gonna put an application in for Pine Terrace Apartments in Wrightsville.
If I can, I will.
Warning that this was coming up.
No.
I don't have any questions.
Mr. Adams, you got questions?
Just a couple. From your conversations with my client, is there any chance that she might move back into the program?
No.
Okay. And did she tell you the name of the person or people that she's residing with?
This morning, she indicated the Odie.
Otha.
Oh, Otha.
All right, let's get one thing straight in this courtroom. If you don't know, just tell me you don't know, and I'll ask you shortly. You don't tell the witness who it is. You understand, Ms. Jones?
Yes, sir, I'm sorry.
Thank you.
The individual name started with an O, something Odie, something to the effect of that. She mentioned it this morning.
But she didn't give you an address and a phone number?
No, she didn't. She had to message the individual for the address.
Okay, so she said she's trying to get that information. Is that right?
Correct.
Now, it appears, and tell me if I'm correct, the mother immediately informed you that this happened. Is that right?
Yes, I was going to the home to do another walk through the home prior to court, and she called me and she indicated that her grandmother had just asked her to leave.
And she is still gainfully employed, is that correct?
Yes, she started employment, I think the 18th or 19th.
And she giving you check stubs or any proof electronically that she's employed there?
She showed me a check stub this morning.
Now, as far as visitation, I know that you've got to go through a process to try to prove that, but it was the department's or the division's intention to ask the court to grant some additional visitation, is that right?
The intent was from the last court hearing for mom to have visits at her grandmother's home.
Well, that hasn't fell through. Do you have any alternative way the court could give her additional time for the children?
She's already receiving additional time. She's visiting 2 times a week for 2 hours on Wednesdays and Thursdays. With the kids going to school, it may be hard to give her some additional hours throughout the week, other than those 4.
So there'd be no way to let her have a period of unsupervised visitation on like a Saturday or something?
We would need to know where this unsupervised visitation would be held.
No more questions, Your Honor.
Ms. Devaney, you have any questions?
Yeah, Your Honor.
Mr. Roberts, questions on the children's behalf?
No questions, Your Honor.
Here we go, guys.
Well, I'm going to ask.
Doesn't he sound so proud of himself? I'm going to ask, since none of you all asked, and I want to know, I'm going to ask, because I'm the judge and I can do that.
Why was the mother asked to leave the home?
Whenever I spoke with the mother indicated that the grandmother felt as if she got the job in Wrightsville so that she would not have to stay in her home. Whenever I reached out and I talked to the grandmother indicated that she felt as if the mother would be spending more time outside of the home than in Wrightsville. And she did not want her to use that as her address if that's not where she would be laying her head.
Thank you. Any follow-up from anyone?
No, Your Honor.
Thank you, Ms. Jordan. Step down. Anything else, Mr. Butler?
No, Your Honor.
Mr. Adams?
Your Honor, my client does not wish to testify. She says she can't add anything else. You have not read it.
I don't know what he said there. I did hear, Your Honor, my client does not wish to testify. She said, "Brr, brr, 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 brr."
Ms. Devaney?
Nothing on behalf of the father, Your Honor.
Evidence, Mr. Roberts?
No evidence, Your Honor.
Mr. Cobb? How are you this morning, sir?
Looking better, Your Honor.
Good. What you want to tell me about this situation?
Nothing else I can add, sir.
All right. Now, I do need to ask this, and I should have done this early on. The children are not present. Did I miss a request to excuse them?
Did you send a request?
Yes, I sent a request, and I actually sent a follow-up email. Ms. Carol said the only one that she hadn't heard from at the time was the judge. She'll reach back out to me, but the email went out.
If it went out from, Karen's email, you may not have got it.
Okay, yeah.
One, but
No, what it is, it's an email issue problem with the 8th district that we utilize when there's someone that's not been approved. It kicks everything off into, I don't want to call it junk email, but unread email that I have to go in and specifically admit. And I did not see one in this from
Georgia.
Miss Butler, but now I could have very well missed it because there'll be 8 or 10 of them, in there. So, all right, I'm going to remedy that when I get back, Mr. Butler. All right. So there was a request to excuse the children. Everybody got it but me, so there's no objection to it. I'm assuming, Mr. Roberts.
No objection to that, Your Honor.
Any objection, Mr. Adams?
No objection.
Ms. Devaney?
No, Your Honor.
For the record, thank y'all. All right, Mr. Butler, what you want to tell me?
One hurdle is down and another jumps up. But there is employment, there is income. One county is resolved, at least 2 more to go. And stability. And not only the home, but the employment, what we have to look for now, Judge. And then get the new home assessed. I'd like to get that one assessed.
So that's the prosecutor. This isn't a criminal case. But her lawyer is over there, and he just put forth all the good things about her. It's stretching the truth as much as he can without breaking it, when he's sort of supposed to be on the other side of the fence. But don't worry, there is a prosecutor in this room. We're about to hear him. Hi, Donald.
Mr. Adams, what you want to tell me? Ms. Devaney?
Your Honor, there's nothing I can have of my father today.
Mr. Roberts?
Nothing to add, Your Honor. Just glad know we've made progress, and I think we all know the criminal problems can be difficult for anyone to solve on their own. So hopefully all that can be resolved soon, and we can get these children where they need to be, Your Honor.
I don't know that I'd use the word progress in the case. I'll be quite frank with everyone. The issues that I see left here today do not deal with the criminal charges. I know they're floating around out there, but I'm also aware of the fact that they could take years to get resolved. These children could be 18 before they get the criminal charges resolved. But those things that this mother can directly resolve are not getting resolved. Now, I understand she went through the drug treatment program, and I understand she's gotten out of that. I congratulate her for that. And I know we haven't been out 6 months, but she is working. But the stability in the home is, I don't know what's going on there. I've not been offered any explanation other than what I've heard from my case manager in this case. And I am certain that there is, I've been doing this long enough to know that I'm certain in my mind that there's more to it than what I've heard here today. I don't know what that is, but there's more to it. Ms. Jones, quite frankly, I was ready to start transitioning these children into your home, but for the fact that, and I'm glad that I don't think Mr. Butler even knew that about this last night, for the look on his face when his caseworker told everyone that. We'd have been traveling under, if we had traveled under the case manager report, we wouldn't have known that this morning. We would learn that after the fact. I would have been making probably some rulings based upon things that no longer existed, facts that no longer existed. I've got a mother here today who doesn't even know where she's residing, cannot even give us an address. I don't even know who she's residing with. I don't know if she's going to get a home for these children anywhere. You know, I've heard she got applications here, here, and here, but no approvals because she needs a birth certificate. Okay. Last time I checked, it wasn't all that hard to get a birth certificate. Some of us were born, I reckon, before birth certificates got recorded everywhere they are recorded now, but you know, even that, you can get a copy of a birth certificate. I'm going to leave it like this, Mr. Adams. I'm going to put the burden back on your client for a little while. I'm not going to make any changes in the custody of these children. Is going to remain with the Division of Family and Children's Services at this point in time. If and when she gets a residence that she wishes for the division to inspect for visitation, she can notify them and you can file a motion for visitation. And I'll address it at that point in time.
Yes.
Now, when I say that, I mean this. I don't mean someplace she's going to be for 3 or 4 months with somebody that I don't even know his name. He could have a criminal record that long, or he could be a deacon in First Baptist Church of Soaking. I don't know. But I'm going to be satisfied in my mind that the home that she's going to take these children into just for visitation is appropriate. He's going to undergo a background check if he's going to be in that home. I don't know who he is, Otis or whatever his name is. I don't know anything about him, but I'm going to know all about him before we start any home visits. You understand that, ma'am?
Yes, sir.
What else you want me to cover, Mr. Butler?
I think we are going to have to cover the issue of visitation occurring on Tuesdays and Thursdays.
Wednesdays and Thursdays.
Wednesdays and Thursdays, at what time?
I'm not sure, the time changes sometimes, but it's for 2 hours at CASA.
Well, we got school starting.
They're working on that schedule. I talked to CASA yesterday.
Casa, you're talking about Casa by day now?
Yes.
They go, with the children starting school, they're going to change the time. Is that correct, Ms. Townsend?
Yes, they're working on those schedules now.
When does school begin in Toombs County? Does anyone know?
August the 7th.
August?
The 7th.
That's right around the corner. Okay. Ms. Townsend, when are you going to know something from the new times?
I will talk to my coworkers to see, but normally what our visitation center Friday did, because of August starting schools, they try to work their August schedules with schools, the school times. So they'll drop to the afternoon time, but I will check with Ms. O'Neill after 4.
Well, what I need to know is what Mr. Butler needs to know, and he needs to know it right away, is the new time the mother's going to visit, because I want that in the order. Because if this comes back before me between now and 12/31/24, I want to be able to look at the mother and say, these were the times that you were allowed visitation. Have you visited? Why haven't you visited? I don't want to hear, well, it conflicts with my work schedule. It conflicts with this. It conflicts with that. I want a definite time in Mr. Butler's order. You understand that, Mr. Butler? You understand that, Mr. Adams?
Yes, sir.
You understand that, ma'am?
Yes, sir. You're going to keep it to 2 hours, 2 days a week?
2 hours, 2 days a week. I'm going to leave it like it is. I didn't order any changes in that other than the time to accommodate the children being in school.
Yes.
I'm assuming that the mother's got her own transportation to visitation. That wasn't mentioned. I should have asked that. Okay. Understanding? Good. All right. You'll hear from Ms. Townsend, I'm sure, by 5 o'clock tomorrow, Mr. Butler. So you can do your order. Yes, ma'am. Anything else?
No, sir.
Okay. All right. And that completes the Jones matter.
I love that judge. I don't know about that judge. I love that judge. I loved watching him. I loved hearing him. I loved how he said everything. I loved what he said. I don't even know what else went on. I don't even know who's in the courtroom. I just saw the judge. Um, if you are a higher level member than just the first tier, then I have a bonus clip of this judge already uploaded. There's one part of it that you're gonna love. It's real short. It's like, I don't know, 13, 17 minutes. I don't know. I don't remember. Okay. All right. Next, we'll go to an attorney who wants to withdraw. And that guy from Florida. That guy from Florida. Yep, there he is. I just thought the first part was great, so I left it, but I'm gonna fast forward it now. There's the other lawyer.
Okay, no problem. Record, please. In session, the Honorable Judge Edward S. Domnarski. Good afternoon, Your Honor. You're on mute, Your Honor.
Good afternoon, everyone. What is our first ready matter?
First ready matter is Redding Pierre versus St. Pierre LLC.
All right, bear with me while I get to that case.
Hello, Your Honor.
All right, this is the matter of Redding, Pierre Redding versus St. Pierre. Would you identify for the record, please?
Your Honor, I'm Attorney Michael Budlong. I'm here with Mr. Redding. He obviously is here as well, and it's my motion to withdraw.
Right. And Mr. Redding is with you at your location, Attorney Budlong?
No, he's in Florida, it would appear.
Okay, is he with us here today? Yes, I do. Okay, I do see you. Okay, can you hear me, Mr. Redding?
I can.
Okay, I do see you now. Thank you. All right, who else would like to identify in this matter?
Your Honor, Rebecca Hartley on behalf of the defendant, J. St. Pierre.
Anyone else?
And I don't see Attorney Hartley. She may be only by voice only, huh?
No, I did hear her. And all right, anyone else on this matter? All right, Attorney Budlong, I'll hear you.
Well, Your Honor, this matter was scheduled for trial, and as of last Thursday, I'm no longer contagious with COVID, and the matter has not been rescheduled. Mr. Redding and I have had a number of communications, and it is clear that there has been a complete breakdown in the communications between attorney and client. There was a suggestion by the court, I believe, that an agreement be prepared or stipulation be prepared relative to the consequences of the LLC ownership as it impacts the divorce in Florida. And counsel, Attorney Hartley's office or someone in that capacity prepared an agreement. It wasn't perfect, but I certainly thought it got the job done. And my client did not believe that. And he has filed a number of motions, some speaking motions, some not. And he's indicated apparently a willingness to withdraw the matter. There's never been an answer or counterclaim, and I think he's free to withdraw the case should he choose to do so, and let the Florida court decide the issues. And I've not opined as to whether or not there's other issues, but at this point he could withdraw the matter, or it would appear that he has plenty of time to get new counsel. It's clear that we've had some very difficult communications, and since he doesn't seem to want to follow my suggestions as to a number of things, we're really at cross purposes here.
All right. Mr. Pierre, you want to be heard?
Yes, Your Honor. Yeah, unfortunately, my counsel hasn't understood the issue for which I asked him to represent me, which is purely a question of determination of real ownership's rights, for which there is no statute of limitation, and for which the exclusive competence lies in the superior court of the jurisdiction of the properties. And the trial in Florida is in abeyance, it has been held in abeyance, pending the determination by this court, who has exclusive jurisdiction, of what are the exact rights of my rights and the rights of J. St. Pierre in these properties, which basically are we are co-owners, and therefore I'm not going to discuss this here, but my counsel has not got that point, and this settlement is absolutely not suitable to fix the issue and have the court in Florida, the divorce court in Florida, carry out the equitable distribution of the properties.
Your Honor, I would like to see the Florida court's statement that conforms with what Mr. Redding has just said. I frankly would doubt that they would articulate in such a manner, but I would have to see that to believe that. But we do have counsel in Florida who is now on board, I see, and he can opine as to whether or not Mr. Redding's representation as to the Florida court's position or not, as the case may be.
Well, listen, I don't want to make this more difficult than what it is. This is a motion to withdraw filed by plaintiff's counsel. Plaintiff is self-represented. Plaintiff's counsel, Attorney Budlong, is representing a complete breakdown in communication. The case was originally scheduled. This case that was brought by Mr. Redding was scheduled for trial on July 23rd. It was continued because Attorney Budlong was ill. It has not been rescheduled. In the meantime, I'm hearing this motion to withdraw from counsel, permission to withdraw appearance. Let's understand that this case was brought by Mr. Pierre, and the case, or Mr. Redding. The case, it will be set down for trial, and Mr. Redding is going to have to come up here and prove his case. He's plaintiff. That's his obligation. What goes on in Florida, frankly, is of no moment to me. I am dealing with my case in Connecticut. It was brought here by Mr. Redding. We're going to handle it. Mr. Redding has an obligation to prosecute his case. It will be assigned a trial date. So I'm inclined to, what I'm inclined to do, based on what I know at this moment, is to grant, I haven't done it yet, to grant the motion to withdraw appearance, to direct the defendants not to make any motion with regard, well, he's actually, Mr. Redding has already appeared, so I don't have to worry about him being defaulted for failure to appear. We're gonna set it down for a trial. I'll do it more than 30 days from now, and then Mr. Redding is going to have to come up here and present, or whether it's remote or not, Mr. Redding's going to have to prove his case. We can't allow this case in Connecticut to simply not do anything while the parties fight in Florida. So you come into court in Connecticut, be prepared to put your case on. That's what I'm inclined to do. Anybody want to be heard?
May I object here? Before setting a new trial date, I respectfully request a hearing, because I filed a motion to withdraw without prejudice, because this case has not been introduced properly, and it's not fulfilling the mandates of the court of Florida, because the problem is this court, your court, is the only, has the exclusive jurisdiction over the disputes of ownership of the properties that are in your location and in your jurisdiction. And the court of Florida has no capacity, no jurisdiction to determine who are the owner, what are the ownership rights, what are the ownership rights of these properties, which have been quit claimed. Therefore, there's absolutely no guarantee whatsoever. And now there's a dispute which has to be adjudicated. And the court to adjudicate the dispute is your court, your honor. And so I intend to withdraw the case or to amend it, either way, in such a way that your court is going to determine which are the rights of ownership of the parties.
Well, you know, wait a second. We don't sit back and do things. We are a court, and the plaintiff, you brought the case. You have the obligation to present your case and make your claims. If you have claims of ownership, you have the burden of proof. So, you know, again, I'm not going to, I'm at least 30 days out, but you're going to have to prove your case. You brought the case.
Well, Your Honor, if I have to prove it, I want to amend it because it's not been introduced properly and I have not been defended properly either.
Well, again, you can do what you want to do, Mr. Redding, but you're going to have to do something.
Yes, I filed a motion, and I think I'm going to withdraw the case and reintroduce the case properly because I haven't been defended at all. My capacities at the trial hearing are not completely jeopardized because of the mismanagement of the case. I had a lawyer I was relying on, and nothing has been done. And so I need to make a decision here. Either way, amending my complaint or withdraw it and file a new one, which is going to be in conformity with what I need, with what is needed for the case in Florida.
Do you have counsel in Florida, Mr. Redding?
No, Your Honor, I don't have counsel at this time in Florida. The case
that may be something you want to consider. You may want to consider counsel in Florida because counsel in Florida may be able to give you some guidance as to whether or not it is necessary for you to take action here in Connecticut. Because I'm not ruling on it, but I've been informed in various arguments and sessions with the court that the Florida court may consider this to be marital property regardless of ownership. I'm not ruling that. I'm just saying you may want to get some guidance on that from Florida counsel because maybe it would not be necessary for you to bring this action or to continue this action in Connecticut. All I'm urging you to do is get counsel in Florida so you can be advised as to Florida law. I can understand you may not want to take the representation of defendant's counsel in Florida or your wife's counsel. I don't know which party it is, wife's counsel in Florida, but you really ought to get counsel in Florida to give you guidance. But putting that aside, I'm going to grant the motion to withdraw, and I'm going to set a trial. I'm going to direct that the case be set down for trial no earlier than 30 days from now. It may be longer than that. I don't know. No earlier than 30 days. In the meantime, you can decide how you're going to proceed, Mr. Redding.
All right. And Your Honor, if I may make a remark, I had a counsel in Florida and he agreed with me. And by the way, I have half a century of experience in real estate. And I can assure you that my ownership rights in these properties are, I'm a co-owner, but my opponent is disputing that in the court. And that's why I need your court to determine which are the ownership rights. And the judge in the court of Florida has put the trial. The trial was scheduled for June 26th, and it has been postponed because we are waiting for this court to determine the rights of so that the court in Florida can proceed with the equitable distribution. So if I can file a motion for clarification in the court of Florida, and as to is the judge does he believe he can proceed with the equitable distribution under the circumstance where two of the properties are in the name of the LLC. I can file a motion for clarification and see what's going on. Sure.
Well, listen, I appreciate what you've told me. My concern is that this case has to be prosecuted. I indicated to you I would set the date no earlier than 30 days. I will, if you wish to have the trial date further out, I'll hear you. Please tell me your position, because my point is we've got to set this case down for trial, and you have the burden of proof as the plaintiff. So tell me what your suggestion is as far as a trial.
My suggestion is that I'm going to withdraw my without prejudice, and I'm going to refile a complaint that's going to be handled properly, and that's with purely for declaratory relief, which means that I want to have this court adjudicate exactly what are the rights of the parties, and which I know are co-ownership rights, but it's not apparent from anywhere because these quitclaim deeds are absolutely not specifying. And my opponent in the court in Miami is pretending that the properties are hers as personal properties. So that is
well, listen, sir, you can do what you want to do, but you got to do something, okay? If you want to withdraw this case, please do that. You can do that, and then you can start again, and then we'll deal with a new case as we will any other new case. But for the time being, I asked you about this case in terms of a trial date. I'm inclined to say no earlier than 30 days. Now, do you want? I'm offering you the opportunity if you want some additional time on that.
I'm fine. I filed my motion for withdrawal.
Well, you don't have to file a motion for withdrawal. You just have to withdraw the case. You can find that form online, or Attorney Budlong, I'm sure, can give you guidance. You can withdraw the case without a motion. You just withdraw it.
I've told him that today, Your Honor.
Well, so Your Honor, I need a withdrawal without prejudice.
You just file a withdrawal. It is what it is. I'm not going to pass on that. All I'm doing, I'm going to give this case a trial date. And it sounds like it's going to be no earlier than 30 days from now. And you can do what you want to do.
And Your Honor, would you not adjudicate my motion to withdraw?
I don't have to adjudicate it at all. It's a voluntary motion that you file. You're a plaintiff. You can withdraw your own case if you want.
And I can refile it?
I'm not giving you advice, sir.
No.
You have a lawyer that I'm not going to give you an advice. I'm just indicating to you, you brought the case, you can withdraw it. There's a form online called the withdrawal form.
I know, Your Honor.
I know, Your Honor.
All right, so I am going to grant Attorney Budlong's motion to withdraw. That was, what was your motion number, Attorney Budlong? Number 118. I'm granting the motion to withdraw appearance, and I'm going to direct the case flow to set this down for another trial date no earlier than 30 days from now. And then in the meantime, if plaintiff withdraws the case will go away, and then plaintiff can proceed. Anything more from anyone on this case?
No. Thank you, Your Honor.
I wish you all the best of luck. Thank you.
Thank you, Judge.
Bye, Pierre. Listen, I'm going out on a limb, and I'm going to say Pierre is French, because it's Pierre. Isn't that French? Okay, I'm a, ignorant American about geography, but Pierre to me sounds pretty gosh darn French. Okay, now it's time for Fleischer. I can't do no more, guys. I mean, I want to put that guy's face up one more time, but I don't think me or Maiko can actually handle it. I think we we need a break before we do that again. So I'm not going to. I almost did. Oh, Canadian, but that's French, right? I mean, that's French. So, Fleischer, where are you, Fleischer? It's time to normalize and get into Fleischer's courtroom and get back to normal again. Whew.
The living man.
Steven, do you want to call the one in the hallway?
And I forgot to say yesterday how nice his haircut looks, so I'll say it today. His haircut looks nice.
I'm in just because he was the first one up.
All right, page 1 and 2, Judge.
Avendano?
Avendano.
Yes, sir.
Come up.
Step all the way up for me.
I'm not sure if this is the guy or not, but if it is, I'm so sorry to do this to you right off the bat. I thought we had more time, but I might have to apologize before this guy starts talking, so I'm very sorry.
Mr. Avendano, you're charged 2 counts of assault of a family member. You're facing up to a year in jail and or a $4,000 fine.
Oh, yes, sir.
So, how many times has Mr. Avendano sticked out on us?
Sorry about the volume as well. I can't control the microphones in other people's courtrooms, even though people think I can. He fixes it. It gets better. Breathe through it.
You know,
Judge, this is the second PR bond. So,
Want to explain?
no,
Okay.
nope. What are you doing like, Mr. Avendano?
Marine. I've been working in the city of Houston undercover. So that's why I skipped out on, oh, I didn't really, but my phone was lost and I couldn't contact the court, but it wasn't intentional. So a friend,
All I'm waiting for is you've been abducted by aliens. That's all I'm waiting for.
oh, I understand, sir. Close enough.
Here's what we're gonna do. I'm gonna appoint your lawyer, and we're gonna figure out what we're doing here.
Okay,
All
sir.
right, take a seat in the jury box.
Thank you.
all right, Judge, next is page 10.
We all are.
Henderson,
We all are,
Demarion.
Rebecca.
Good morning, Mr. Henderson. Sir, you are charged with unlawful possession. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can will be used against you. You have the right to have an attorney present. And our 41 will be appointed to you, sir.
Judge, on July 22nd, 2024, officers with crime suppression observed a vehicle traveling without a rear license plate at night and conducted a traffic stop. Driver was ID'd by his name and date of birth, and he had a felony warrant out of the 263rd. Upon contact, officers could smell a strong odor of marijuana. Search discovered 8.4 grams of marijuana and a Glock, which came back as stolen out of Louisiana.
All right. Mr. Henderson, I'm going to find that there's probable cause to go forward with the case. So he has an open aggravated assault.
Out of the 263rd, yes, Judge.
Mr. Henderson, how old are you?
19.
What do you do for a living?
I work for a moving company.
Did you graduate from high school?
No, sir, I'm going back to school for my GED as we speak.
You and I are going to start doing that together.
Yes, sir.
The first thing that I'm going to do with you is you will sign with me today an affidavit.
Yes, sir.
This is a promise that you're going to make to me
Yes, sir.
that you're not to have any weapons whatsoever.
Yes, sir.
I don't care what's going on in your life. I don't care what you're going, where you're going. I don't care what you're doing. I don't care who you hang out with. If I find that you have a weapon, You'll be facing an additional 6 months in jail on a contempt charge. Every single time you have a weapon, up to 6 months in jail and or $500 fine. Do you understand? I will tell you now. 31 days
Yes,
from today,
Jason.
you will get tested for dope. If I find that you continue to smoke weed, likewise, I'm going to put you in jail. You will be earning your GED from a pair of black bars behind you. I will appoint you a lawyer today. And in 2 weeks, I want you back here to show me what you have done to get your GED and get those classes to start rolling. If you've done nothing, you and I are not going to be dancing. Who do you have with you in your life now?
Right now I stay with my girlfriend.
Do you have a mother?
Yes, sir.
Do you have a father?
No, well, I do have a father, but he's not in my life.
Where is your father?
As now, I'm not aware.
It's apparent to me that you have no structure in your life, and you have no one that's coming down to you, bringing down the rain of showing you what is right and showing you what is wrong. I am that person now that is going to do that for you. And if you act like a little child, I will put you up on my knee and I will spank you like a little child, but I'm going to do it with a ton of jail time. Do you understand, Mr. Henderson? No more acting like a fool while you're out there in the free world, because I will take it away from you in a heartbeat. I will do everything in my power to protect every single person in Harris County. Do you understand? 2 weeks, you will be back here. Show me what you've done. Number one. Number two, do you have a Texas driver license? Then you will not be driving as well. In this affidavit, you will be promising me that you're not going to drive. The next thing I'm going to do is I'm going to put an ankle monitor on you and I'm giving you a curfew. I don't want you out in the middle of the night because I can't trust you. You go out past 9 p.m. You and I will not be dancing.
Ramona is back there right now trying to get the IT guy to fix the sound.
I'm going to keep you so close to me that you're going to think that we're going to. This is an affidavit. No weapons. No driving. Are you clear?
Yes, sir.
All right. Can you reach out to the public defense office, please?
Yes.
Tracy, waive the fees, GPS monitor, no driving, 9 p.m. to 6 a.m. And then we'll bring him back in 2 weeks. And then we will also test him 31 days from today to see if he's got any buildings.
All right, Judge, the last arraignment we have is page 2122, right? Come on up.
Hi, Ramona. Thank you, Ramona. Judge fixed it.
Yes. I'm good, how are you?
Don't pick on Jackie.
All right, is discovery complete? Offers made? Offers made? Okay. Yeah, that's fine. 829, waive the parents pending litigation. All right, got it. You're welcome.
Okay, pick on Jackie.
Hey, what's up? Oh, yes, the traffic, the traffic. I fell asleep.
All right.
Judge, this one was taken into custody last time. Just a heads up.
Okay.
There's Carl sneaking around back there. And there's Will. Linus. There's Will. I know you should be in bed though, Linus. Go to bed.
I don't know, I think that either the cleaning crew or something are doing something with the mic.
Linus, did you see the thumbnail for this
What is this thing?
stream? I made that for
What is
you.
it?
Page 21 and 22, last name Wright.
And yet another case. Another.
New program now.
Ha!
Yeah.
That's cute. Mr. Wright,
I tell
you
myself.
I didn't ask you to say anything. All were now, so you were on bond for criminal mischief and a criminal trespass. And the bonds were at 5,003. So that indicates to me that you've taken off of us numerous times or some other kind of issue. You've now picked up a third case of another criminal mischief. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Wait, so this is from 3-5. Are we done? You see on this?
So not for the newer case.
Stop. I don't need your help.
For the criminal mischief,
The new one.
correct.
Was it a 2B?
Yes, a 2B was issued, yes, it was an open warrant for a little while.
We're trying to tell him it's already fixed, but the IT guy's here anyway.
Mr. Wright, you're charged with another criminal mischief. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
Judge, on March 5th, 2024, officers were dispatched to a family disturbance call in Harris County, Texas. Officers made contact with the complainant witness who stated her brother, the defendant, came to her apartment to bring food for his toddler son that was staying with the complainant witness. The complainant witness stated that the defendant became upset and angry at her after she told the defendant that he could not use her car. Complaining witness stated she told the defendant she was going to call the police if he did not leave her apartment. The defendant then attempted to grab the complaining witness's phone. The complaining witness then went to her neighbors and called the police, and the defendant followed and kicked the neighbor's front door, but then walked back inside the complaining witness' house and broke a glass coffee table by throwing it on the floor and attempted to break the complaining witness's TV. But the complaining witness's 18-year-old son was able to stop the defendant from doing so. The defendant then went outside and began to kick the garage door in an attempt to open it to get to the complaining witness's vehicle. The complaining witness's 9-year-old daughter witnessed the defendant kick the garage door multiple times, which caused it to be bent and off the rails. The total value of damage was $500.
What do we do with the person who continually fails to live up to the conditions that we put? Not without a lawyer. What I'm going to do now, though, is I'm keeping you. You will stay with me. I will appoint your lawyer, and we are going to figure out what to do with you, Mr. Wright. But you have some anger issues that we need to get through. We need to get to
my programs. I just had turned my programs in. I was going to my programming today. I got it on my phone. They told me to go to Westheimer today. To go to 5:30. I was really going today. I was really going, sir.
You know how many times I heard that?
I get all that, but I was really going now.
You know how many times I hear that?
I understand, sir.
So he goes with you.
I think John is pointing out his other two.
We'll contact John and then figure out. Where did Eric go?
To ask for Mona what is the sound level.
Okay. Will.
Is there, are there the readings?
Yes.
Yeah.
Okay. Approaching, it's actually off on Mr. Chua. We discussed him yesterday. He's here present with his son. We just wanted to make sure that he was okay on the payment plan for his PTI.
You mind bringing him up?
I don't mind at all. Okay. No, just you.
So who's charged? Dad or son?
Dad.
Dad. Okay. So I don't know why son is.
249-009.
How about it? I don't know.
Judge Ramona said that you could be heard now.
We need to move that because
Guys, that's Will.
on top of it.
In case
They're
you
not
didn't know.
being heard.
That was
Because
Will.
if you're within like, I think, was it 10 inches of that mic, there's a dead zone.
If you're within
So we can
10
put
inches of
one
that
back,
mic,
and you
it's
can
a
use,
dead zone.
just put it on right there. Yeah. And then
Right,
this is
Will?
Zoom. This should- okay, Zoom is supposed to be able to do the thing, but if YouTube is not allowing it, then we'd have to put like some good.
We'll see. Hopefully this will. Ramona, I guess will you give me a heads up? Okay. Can you give me the cause number? Will,
Yes, sir. 249-0090.
No.
So refresh my memory, but
So this is on the trial docket.
Right.
The criminal mischief case. We've had an agreement with the state for a 6-month PTI. Only condition of restitution is $2,500. The court asked Mr. Chua to be here today to ensure that he's able to pay that, which I've spoken to him about his monthly income versus expenses. And he's good to go on that, but you wanted him to come to be sure that was going to happen.
today is the day of trial. Usually, if you're ready, we bring a jury in and we're ready to go into trial. You have worked out an agreement. This is something that should have been done a very, very long time ago, not 8 months later. So I'm keeping you on a very strict schedule as far as payment is concerned. And the one time you start to play games with me, you will go to trial. I will not play games with you. Do you understand, Mr. Chua?
Yes, Your Honor.
What do you do for a living,
No
sir?
idea what he did.
I've been a retired organ transplant nurse since 2017, but I've been sick of pneumonia and then the COVID, so I decided to retire.
He does get retirement, Your Honor, monthly.
Okay. How are you planning on getting $2,500 to pay restitution?
If I may, Your Honor, he gets $2,100 in retirement per month. And he works out his expenses to about $600 per month. And so he has a surplus of $1,500 minus a couple expenses. And with the $2,500 over 6 months, it's about $400 a month. And so he says it's going to be tight, but he's confident he can make it work. Also, for the court's information, we've gotten his insurance involved, and I've been talking to his adjuster on possibly helping us out. But I told him to assume that's not going to happen and to be prepared to pay for it himself, which he can, but we also have that backup plan as well.
I'm not going to play games with you. I want you to understand that at the first time that you stop paying or you don't pay as you're supposed to pay, you will immediately be set for trial and this deal goes away.
Yes, Your Honor.
Do you understand? I have way too much drama in my life. I don't need any more. I don't need to babysit another case. I already have 2,500 cases that I babysit. Do you understand?
Yes, Your Honor.
So how, because they can't take the money. I don't know how.
They're emergency set up to do that through the probation office, Your Honor. He has a meeting scheduled August 20th. It's his first meeting.
So if by August 20th, he should make at least 2 payments then.
Whatever he's worked out with probation.
What about the complaining witness in this case? Who is the complaining witness?
Neighbor of his, lives a couple houses down.
Okay. Don't have any contact with these people as well.
Yes, Your Honor.
Do you understand?
As part of this agreement, I want to make sure that they don't have contact and that he doesn't have any weapons as well. Okay. And then let's revisit this in the month, Shatoria, and let's figure out how, or I guess, you said August 30th
20th, Your
or
Honor.
28th?
20th.
20th. So let's regroup that August 26th. And let's see how he's done. By that time, he should have at least 2 payments into the registry. Okay. If you make these payments as you're supposed to, this case will be dismissed. Okay. But no games. You understand? Okay. Good luck to you, Mr. Chua. All right. Thanks. No, not all, just the 2 old ones. Yeah, you know what? I don't even think you should get a PR bond on the new one too. I mean, he's got 2 open cases. They're 5,003 and then he picks up another one. Yeah, no PR bond. Let me take a look at it. Give me a second. When does he expire?
September 16th. So they wanted to do a 6-month extension.
Why? I mean, he still has until September. Why
Okay.
do an extension?
So they both had blue shirts on. This is the guy I need to apologize about, not the other one. Unless this is the other one, but I don't think so. I think this is a different guy.
You know why you're here, right?
Yeah, because I haven't completed a class.
You haven't done a bunch of stuff. And in lieu of me filing a warrant or issuing a warrant and putting your butt in jail, we kind of have like a come to Jesus meeting now in an effort to try to get you to understand that if you don't get this done, I will put you in jail. You're looking at 6 months. And then what happens? You lose your job. So something has to change because the way things have been going now, it's not working. What's going to change?
She said I have one class that I have to do.
You have 30 hours of community service. You have your DWI repeat offender class. That in and of itself is 32 hours.
Yes, sir. On the 12th, is my next time off for 10 days, and I told her that I would complete the community service then. The way she was having me do everything, she said, well, she was pushing for me to wait till the end to do the community service. I don't know why. But that's just what she was pushing for. And having me get some of these other classes done. And then on the class, I just got where I was scheduled working on a permanent boat to where I'm going to look and see about getting Wi-Fi so I can do the classes online on the boat because I work offshore.
You know, they have the devices that you can take with you where it's kind of like a satellite Wi-Fi signal so that you can do it remotely from anywhere in the world.
Jackie, thank you.
It would probably
Thank you,
behoove you to
you.
look into that.
That's what I was, I just got off the boat yesterday. I had another case in Hutchinson County and I had to pay it off so I could get off the probation. So I've been riding over.
You're on probation for what else?
The DWI in Harris County, I mean, not Harris, in Hutchinson County.
How many DWIs do you have open?
So there's 2, or is there 2 or 3?
How do you not know?
Because they ran one together, and I think it's 2. I'm on 3. I was on 3 probations. The one on, I don't remember what court it is.
In what alternate universe do you think that you can be on multiple 2, if not 3 probations, and you fail to live up and there's no jail time involved?
I'm completing.
Mr. Cassidy.
I'm completing them. The Harris County one, I mean, not the Harris, the Hutchinson County one. I'm completing that. I've said get off of it in a couple days.
I don't give a rat's behind about to complete.
And then you sent me to the rehab. I completed the rehab. I completed one previous class. I paid the other one off the $3,000. I'm on a monitor. I pay my monitor. I haven't failed no urine test. I've gone to probation.
What monitor do you have now?
The blow monitor.
Where is it?
In the car.
How often do you drive?
I don't drive.
So you're not using the monitor?
No, I do. I use it all the time in the car. That's the one they told me to get. That's the one I got. I'm blowing it all the time. I'm not failing none of them. Like anytime I go somewhere, my wife drives. We get in the car. I blow the monitor. I pay for the monitor. I'm trying here. I'm really trying. I've got a lot that I have to pay for and a lot of stuff like that. And then I was laid off and I haven't been able to
Mr.
afford
Cassidy, the easiest solution is don't get into a car and drive.
Yes, sir.
And the thing is that
affidavit, sir, to not to drive. I don't have a driver's license. I don't drive. I don't drink anymore. You sent me to the rehab. Ever since you've done that, I've been trying to.
Mr. Cassidy, what happens if you pick up another DWI?
Oh, I'm going to prison.
Right.
So like I said, I just give it all up. The last time I was in there, I actually put me on a monitor. You sent me to rehab, which helped significantly.
When do you go back to the boat?
The 1st, and I'll get off the 12th. I just took off to come to court.
So that's you get back on the boat in 2 days.
Yes, sir. And then I get off the 12th. And I'll be off 10 days from the 12th to the 22nd.
So you get off the boat on the 12th.
Yes, sir. And I was going to do start my community service. Then in 30 hours, I can get it all done before I go back to 22nd of August.
How I don't even know how we're going to do the education course.
I would recommend doing the DWI education class during that week, that 10 days that he's here. If you do it online, you would really have to.
I would recommend start the whole process over, hook him up to a polygraph, connect it to a taser, and then let's try this all over again.
Find somebody who's going to let you miss at least 2 classes.
So that's the thing. I was trying to find out a class where I could do it while I came in, and they said that's impossible because if I miss one class, because see, these classes are structured in a way. Yes, sir.
There's a particular schedule you're supposed to conform to.
Yes, sir.
That's the way it's structured. That's the way that you're supposed to learn from it.
Yes, sir.
It's not supposed to be your way. It's their way.
I understand.
So what you need to do now is you need to go find Wi-Fi that you can take with you on the boat.
Yes, sir. That was my next stop. I just got off the boat.
Now, can he do the
online?
The repeat offender online? Okay.
I'm trying to figure it out.
So I'm giving you the way now before I issue the warrant.
Yes, sir.
Because I'm going to make notations about how many DWI probations you're on. If you fail me one more time, because you've already failed me now, and I'm bringing you in an effort to give you the opportunity to straighten up and fly right.
Yes, sir.
If you do not, with how many DWIs, I'm going to hammer you. Forewarned is fair warned.
Yes, sir.
Do you understand?
Yes, sir.
When you leave right now,
Yes, sir.
I want you to either go to Verizon, go to T-Mobile, go to AT&T, and find out about Wi-Fi that you can take with you everywhere you go, so you can get this class done.
Yes, sir.
I want you to enroll now in the DWI education class. You have until the 22nd of this month to have the education class done. Of next month, sorry.
Yes, sir.
Until August, because that gives you from now until August 22nd.
I want to say the class is like 9 weeks long.
It's
9 or 12 weeks long.
7 to 8 weeks.
Yes,
right?
Oh, 7 to 8 weeks. Okay.
Mhm.
The one I called, they said it was 9 or 12 weeks long. Oh, you okay? Thank you, ma'am. And do you know how much? I mean, no, they don't tell you how much.
I don't know how much.
She said it was like $400 or $500 to do it. I didn't know.
DWI is not cheap, man.
I understand that.
$15 on an Uber will get you anywhere you want to go,
Yes, sir.
no matter where you want to go.
I understand.
If anything you've learned from anything, use Uber.
Yes, sir.
Anytime I go out, because I like to go out with my wife, go out to eat, and I like to drink.
Yes, sir.
And I always take an Uber.
Yes, sir.
Every single time I go out, because it's not worth it. I want to give him enough time, but I'm not going to give you an open invitation anymore. We tried that. It's not worked. So now I'm going to have to sit here and micromanage you to make sure it gets done before we issue the warrant. So what is a reasonable time that we can give him that he can have the education class?
Hey, guys, keep it down, keep it down, please.
Do you have funds right now? Like this financial, finance?
Right now, I just sent, I got one more payment of 1,000 to send to the other one, then I'm off of that. And as soon as I get done with that, I can start paying for the course. I have like,
When is that due over there?
I should get paid again on the 7th, and I'm gonna send my last $1,000 payment, and I get off of that. And then as soon as I get off of that, I was gonna start paying for this. When I first got out, I didn't have a license. I didn't have a ride to get to work. It's taking me a while, and I had to pay for the monitor.
So tell me a date next month that you can sign up for the DWI education class. And I mean, does he have to pay all at once, or
I have to
go?
Most of the time they will.
Sir, I want to say they said I could pay like half of it and then half of it when I get done, but I have to find a date that the class is allowing people to enroll. I have to start calling. I have no idea when they allow it because they do like an enrollment like every month
So
or
let's
every
do
6
this.
weeks. I have to figure
Let's do
it out.
this. I want you to come back to me August 12th, and I want you to tell me what class you've enrolled into.
That's the day I
You
get
get
off.
back, right?
I don't
get
know
off
what he
the
drinks for
boat.
real.
So come back the 13th?
Probably wine.
Can I 13th to the 14th, somewhere in there?
Sure.
I don't know what time I get off the boat. Like yesterday, I didn't get off until 6 o'clock in the afternoon, and I was all the way.
Pick a day, the week of the 12th. I want you back here, but I want you to have signed up for the education class.
Sometime the week of the 12th, 13th, to 14th.
Right, you can
Okay.
come here, but I want you to have signed up for the class.
I'll look into it today. Right now I got about, I want to say I got $800. I'm gonna go, and I just paid everything. I'm gonna go and try and look into the Wi-Fi
Cassidy,
thing.
I don't want to break your bank, and that's
I
why
know.
I'm time. But at the same time, I don't want to issue a warrant for your arrest.
Yes, sir. I don't want you to do that.
Right. Okay? Okay. All right, you're gonna meet with Shatoria, and then good luck to you, sir.
Thank you.
All right. Hey,
I'm here on the regular proceeding. I'm gonna go through them yesterday so he can go home and get the documentation.
okay, where's Mr. Garcia? Come on up.
Fozzie, shouldn't you be working right now?
You come here empty-handed, that's not a good sign.
Well, Judge, he did send it to me electronically.
Oh, okay.
And I'll show it to the state. So here's all of this financial aid stuff. I would have printed it out.
So you're telling me now that he's enrolled into school?
Yes, he's working on his GED and here's the.
This is when I just received the money towards I'm clearing it
So-
for my math currently.
And he's studying for his math.
When is the test?
I just got there, I recently took my language arts, I'm studying for my math now,
Okay.
so as soon as I can
Wait,
get.
so how did it go with language arts?
Yes.
Fantastic. So only one thing is left, which is the math.
3 more subjects, which is social studies, science, and like the math.
Okay, so you're doing math now. When is the test?
As soon as I can feel ready to, get this passage, so I don't have to waste money on doing it.
Judge, I think it's where when you're ready, you can schedule a test, not like the bar exam where it's only offered.
Okay, so let's get a date certain that you want to take the test, that you can study why. I don't want to just leave an open invitation. So you guys talk about it and tell me what day you want to take the test, perhaps 2 weeks from today.
Okay.
That way it gives you enough time to study. And then after that, we'll start working on the next section.
Thank you. Can we be
All right.
excused and we'll be right
Please,
back?
yeah. Thanks. Hey, what's up? All right, Ms. Harbor, you are charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you a 13-month deferred. This is a type of probation that if you complete it successfully, you do not end up with a conviction on your record, but you can't tell people it was dismissed. You did the probation, completed it successfully, and did not end up with a conviction on your record. To be able to do that and successfully complete, you must do first an effective decision-making class. You must do a TRAS, which is an evaluation to see what other conditions you may need. If they assess further conditions, you must fulfill them. No threatening or harassing contact with Brandon Opp. Do you understand? Whatever happened with Opp? Is he still in custody? Do all those cases go away?
Hi, Bill.
All of them? Okay. Are you still with this person now?
I am not currently with this person now, but we were common law married, so we still share bank account, loans, things like that.
Do you have children with him?
No.
Just be careful. That's all I'm going to say. You know, depending on who you hang out with in life, if it's a volatile person, you know, you're going to get caught up in all the drama that surrounds it. Stephen, is she?
I have the first and all that.
Got it. Okay. So just be careful. That's all I'm going to say. You know, you're the one that's on probation. If you pick up a new case, you don't do things on time, like the decision-making class, or you just abscond and take off, or anything, we will issue a warrant, put you in jail, and then you're looking at up to 180 days in jail. Do you understand this? I will make a deal with you, though. If you do everything well, get everything done quick, you're nice to everybody at the probation office, then I'll take you off in half the time. So you can be done with this thing in 7.5 months if you get everything done quick and just be nice to everybody. That's all we want. All right? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you are stuck with us until you complete it successfully, or unless you get revoked. Ms. Harbour, what do you do for a living?
I'm self-associated.
Where at?
She works for Vapor Trends. She's been there for 6 months. She makes $12 an hour.
That's right. And how many, do you have children?
Yes.
How many children do you have?
2.
Or do you have custody of the kids now? They live with you? Okay. You can reduce your fees, please. I'm asking you these questions to see whether we should reduce your fee so you don't pay as much, because you're going to have to pay a monthly supervisory fee. I'll reduce it to the minimum. We'll also give you credit for the time that you spent in jail. That will also help toward your court costs and other fees that you have to pay. If you ever have any issues, come back to us. Don't take off, because that's the worst possible thing that you could do. Also, picking up a new case is also the worst possible thing. All right. How do you plead to the offense? Guilty or not guilty? I will not find you guilty. I will withhold that for 13 months. All you technically need to do is just this decision-making class in the TRS. That's it. All right. Okay. Good luck to you. Thanks.
She'll call you up. Judge, I also have a assignment this morning on Francisco Avendando. From the
Yes.
jury box. Apparently he was, from what I gather, he missed a court date back in February and was recently arrested on it. Also filed a file for evaluation.
Yeah.
Psychiatric evaluation. Also.
Come up, Mr. Avendano. If you ever miss court again, guess what's going to happen? 3 strikes, you're out. You've missed court twice. I'm sorry, you've missed court once. This is your second PR bond. You will not get another one. Do you understand?
Yes, sir.
Jason, tell me about the assaults. Who are the complaining witnesses, please?
The first one, there's 2 complaining witnesses. I believe it was his wife is the first complaining witness, and the grandson is the second.
Where do you live now?
Still here in Houston.
No, you think? Who with, Mr. Avendano?
My wife.
No, Judge, the complaint is mom.
All right.
Yes.
Complainant's his mom.
Mom, his mom, yes. He's living with.
Where does your mom live?
My mom lives in Mexico. This is, they're squatters. They just changed information to make it look like. But, besides the point, my wife is here. Yeah, that was how we judge about that. But, my wife is here in Houston. My mother's in Mexico.
So who is the complaining witness, Pavel?
Claiming to be
Mom and grandson.
claiming to be their family.
That's why there's a motion.
Do you, Mr. Avendano, I just don't want you to get in any more trouble. And I don't want you to have any contact with the complaining witnesses in this case. That's all I'm asking you to do.
Their names are Armandina Avendano and Jose Martinez.
Okay, can you stay away from these people?
Sure, yes.
Are you sure?
Yes, sir.
I don't want to have to put you in jail. But if you force my hand, if you fail to show up, if you pick up a new case, if you have any contact with these people, or if you have any weapons, that's it. Do you understand? It is your responsibility to stay in touch with Carl. He will tell you when you have to come back. Do you have a cell phone?
No.
How is he going to get in contact with you?
I'll find the phone.
No.
He provided me with a cell phone.
I have a cell phone. I just need to replace it.
Do you have another number that he can get in contact with you, or some other method?
I mean, I can fix it. I can only physically go there for now.
So this is what we're going to do. I'm not waiving your appearance. You must appear here in court at the next setting, because I don't know how we're going to get a hold of you. Do you understand? No, that's it. I don't think that we have another choice. So you must be here at the next setting, and we will decide what to do.
Yes, sir.
All right. Okay, Carl.
Thank you. We have a sitting notice, Judge.
Yeah.
I'll see that there.
Hey, do you have a letter opener? A letter opener, perhaps scissors? Do we need to give them a copy of the OR? You know, a lot of times. I don't know if I agree with this, you know? Mr. Wright, you know, why would we do this? You've shown to me that you have no self-control. I would say about 95% of the people who are in custody now, because they have no self-control. They get
been a
upset
while.
and they wig out and they do whatever they want without thinking of consequence. Going to jail. And you do it over and over and over. So why on earth would I accept a time served on this when I know you're going to walk out these doors? Nothing has changed.
He's like enrolled in a mental health program today. Do you have proof of it?
It's amazing, Mr. Wright. It's amazing how when people come to court, they've just now found Jesus. They've just now entered into a rehab facility. They've just now entered into this new other program. You're smiling.
He has a visit scheduled today at 7:30 to the Legacy Community Health Program, Judge.
I don't know much about that program, but this email, indicates that he does have that. I can try to find out more about this program, Judge, but that's.
John.
They told me to come to the intake and take it for 4 to 5 days, but I just say no, you take it.
John, stop. As much as I love you and as much as I like to dispose of cases, which is what we like to do because we don't want to just build the docket up, I think this serves no policy. I don't think this benefits you one iota because, Mr. Wright, not only do you continue to pick up cases, but you are a flight risk and you refuse to address the anger issues. Why are you so angry? Why is it that you flip out in such an easy, in such a minor way that you have to act like a Tasmanian devil? Why? What?
I was drugged.
You were drugged?
I was drugged.
What do you say?
It was on drugs. It was on drugs.
What drugs are you on?
I'm K2. I'm doing the edit.
What the hell is K2? Is that something that's easy?
Synthetic marijuana.
Okay.
I'm just trying, I was just trying to understand what terminology you probably knew what it was. I don't know.
I mean, I know Kush and I know it makes people go just haywire. So if you know that it's going to make you act like this, why continue to do it? Why not the real stuff as opposed to the synthetic stuff?
I'm trying to clean my system with anything, you know.
Well, that's not true because you're here because you.
I turned myself in 4 days. I would go with the warrant. I asked the sheriff did I have a warrant, which they told me. I turned myself in.
CJ, what did he say?
I've been going through the program ever since. I'm trying to go today.
I'm Mr. Wright. I will not take this plea. No, because I'm telling you that this does not help you at all. In fact, in my opinion, it hurts you worse off because you now get the appearance that you can continue to pick up cases. You can continue to miss court. You can continue to break others' property.
I didn't miss court, sir. I ain't never missed court. My lawyer right here. I ain't never missed court. He told me I have to come to court dates. I ain't never missed a court date. I ain't never done to court, sir.
You missed court 411.
Oh, yeah, I was in the
We issued the warrant 412.
Interesting name.
Judge, if I may, can I talk to the state and maybe consider a defer so that he's under supervision?
I think that would be better. And I think that in that instance where we can monitor you, first, I want you to clean up. You're not clean right now. So I will do it with a couple days as a condition so that he can clean himself up. And then I want to work on a treatment plan. Did you graduate from high school? That's the first thing we're going to work on.
You're always first. Yes.
Sobriety will be the next thing that we're going to work on. And then the third thing we're going to work on are two things: anger management classes and getting you a job, because you have way too much time on your hands and you become self-destructive, Mr. Wright.
I'm just trying to get some research. I ain't got no idea.
The mice in your brain need something to do. They need something that's going to keep their attention, that's going to get them thinking, working, because when you don't, You're out on the street wreaking havoc, and I'm done with it. Do you understand? That's where we're at. Thanks,
Judge,
Shandy.
do you want him to go in today and come back in a few days?
So, no, you know, or it's up to however you want to do it. We can work something out now. We can do days as a condition so they can clean up and then work some kind of, let's think about how we're going to do it, John D.
Well, how about if he just, since it looks like when I got here, he was in custody, I guess maybe for the new case and all of that. So maybe
Okay.
we would just bring him back in a few days and then put him on probation there.
Sure. If that's what you want to do, I'm happy to do it. Mr. Wright,
Otherwise, he's gonna have to sit out.
I'm not letting you just walk. It's not going to happen again. And I'm going to tell you now, look at me. Heed this warning because I'm giving you a shot on this now. And if you continue to use Kush, I will put you into a rehab facility, which is at a minimum 9 months if you respond well to treatment. We can either do this the easy way or we're going to do this the hard way. How that happens depends on you.
I'm not throwing away my shot.
You understand? Okay? All right.
Don't let me get the help though. I won't help, John.
Good. And I'm with you. Dan.
Yes, sir.
What's up, man?
Judge, I've got, Mr. Garza, David. Judge, we're asking for a 30-day recess so I can get the mitigation back together. He's 18, Judge. He did have, I'm trying to keep him from having to have this on his record. Now, I'm not saying that it's gonna be not on his record. I'm just saying I'm trying to get a mitigation back together to get to the ADA.
Is it just a UCW? That's it?
He's 18 years old, and this UCW is, yeah, they get for by bus. It was a privately manufactured firearm.
Okay. Is that him there?
Yes, sir.
Push is synthetic.
All right. Come up, Mr. Garza. The other Garza. Good morning, Mr. Garza. Tell me about yourself.
You look nice.
I graduated.
Graduated from high school. Great job. What are you doing now?
I'm working at the restaurant, my family's restaurant.
That's right. Okay. You must have the packet done in its entirety by the 30 days. Your case is old. It's 187 days. I will not give you another reset after this if you don't have it all done. Do you understand? That's more than enough time. You must appear here at the next time with it all done. Okay? All right.
Thank you, Ron.
Thanks, Dan.
Yes, sir.
Have fun.
Yes, sir.
Right this way.
Let me figure it out.
Yeah, but we need to, because he is showing the warrant on my end.
We need to figure it out.
And we need to let this. Procedurally, we have to.
2503-086.
I say it again, you're gonna put it back without anything. Mr. Fosco, Your Honor.
How's jail?
Yes, el caso a la ley.
It's a learning experience to behave and follow the law.
I want you to know that we mean business. No means no. When I had you here last time, all I wanted you to do was tell me the truth. You were not capable of doing that. That's why I put you in. I will give you one more chance now.
Hi, Melissa.
I'm going to let you.
I won't fail you. And I'll do
Well,
it.
what's going to happen now is I will put a monitor on your ankle. And it detects alcohol through perspiration. And I'm warning you now, before you put anything into your body, you must absolutely know what it is. I will not entertain any excuses. Tequila lollipops, hair dye, motor oil. I don't care what it is.
Beer.
If you come to me and you blow hot again, this time I will put you in custody, and you now know there's no one to get you out. So you will be stuck in custody until the case is over with. Do you understand? No alcohol from any source. And no driving. Are we clear? Okay. We need to, so I'm gonna give him a PR bond today. He's gotta come back here tomorrow so that we can put a monitor on his ankle. We will see you back here tomorrow at 8:30 in the morning, and I will send you to get a monitor on your ankle. I will pay for it for you so that there's no excuse why you can't have it. You must charge this thing on a daily basis. If the battery goes dead, so do you. Are we clear? Mr. Frausto, I won't give you any more chances. We will see. I hope so. All right. Okay. All right. So Ms. Broholm, I'm going to let him out. I'm going to, change it to give a scram. After tomorrow, then we'll just give you a 30-day reset.
Okay, thank you so much, Judge.
Okay.
Thank you.
Thanks. Take care.
Judge, did you say 30 days?
No, he's got to come back tomorrow so we can put him a monitor on. Come up, Ms. Johnson. I'm sorry, Ms. Jackson. Sorry. Tell me about yourself.
He
What are you
just
doing
said, I'm
these
sorry,
days?
Miss
What am I
Jackson.
doing these days? Well, I've gotten into the AA meetings, which they're really helping. I'm working. I told you I'm a project manager. So last week I went to Austin. I did a presentation with the Aspen Institute, and that was awesome. And I'm continuing to work as a project manager. In August, I have.
No, you seem like you'd be such a good seller. Like you've got the gift of gab. You've got a great smile. If you could just channel that in a positive way, I mean, you could kill it.
Yes, sir.
Really, you could kill it. I mean,
I appreciate the AA meetings because they are giving me a different outlook and are helping me with my urges. Because I'm not gonna let this beat me. So I'm definitely feeling motivated and dedicated in order for me to stay, getting my life together. My son's about to be in the 4th grade. He's starting school on the 12th. So I'm excited for him. I've been doing school shopping, spending more time with him. It's kind of weird going to the pool with the monitor on my ankle, but I'm not letting the stairs, keep me from my son enjoying the remainder of his summer. And I'm wearing wide leg jeans. I have to change my style up a little bit in order for me to continue.
that's the worst that you have to deal with. It's
Yeah,
nothing.
Absolutely.
All right.
So I really appreciate you giving me the opportunity to continue to show my dedication because I am committed to changing my life and I'm doing that. And I really appreciate that. But I want to, in August, I have 2 opportunities to travel for work. I'm going to Austin again on the 9th I'm visiting the Capitol because I do a lot of policy advocacy work focused on youth that were formerly in foster care because I have lived experience. And on the end of the month, I have an opportunity to go to California because I'm working for, I'm a regional lead for this organization called New Deal for Youth. And it's a lot of advocates around the state. And we do kind of advocacy work.
I'm okay. I'm okay with you traveling. I have no problem with as long as it doesn't interfere with your device and as long as it can still remotely monitor that you're not consuming alcohol.
Yes, sir.
I don't care where you go, as long as you're not consuming, you're not driving, and the monitor's working. That's all I'm concerned about. And I want you to continue to do the AA meetings. You understand?
Yes, sir.
We will now set your case off another couple weeks for you to get more meetings done. You must have another 14 done within 2 weeks.
Okay.
Do you understand?
Yes, sir.
Assuming that everything's fine in the next month, I will take the number of meetings down. But I want to maintain the status quo because you seem to be doing fine. That's all we want. The idea of you coming to court as much as you are and dealing with us as much as you are is to get you to think in the future, if you're ever placed into a situation where you are endangering someone else, like you're out and about in the middle of the night, you're at a bar, you're at somewhere else, and the opportunity comes where you're going to drive, you think twice so you don't make that mistake. That's why we have you doing this, and hopefully it sticks in there somehow. All right? All right, so we'll see you in a couple weeks.
Am I still okay in order for me to document my meetings? Because I've
This is
printed out
great.
the paperwork and I can document.
This is great. Just keep it up. That's all. Okay?
Thank you.
All right. Good luck with all your meetings. Just kill it.
Thank you
That's
so
it.
much, sir. Have a great rest of your day.
Michael, I was going to, and I can't. I can't show his face again. If you guys want to see his face, you gotta rewind because I can't do it. Nope. I just stopped it on that good, wholesome moment. And we're gonna keep it on that wholesome moment, guys. Oh man. Okay. That's all I have for today. If you're here for court videos, bye-bye. Thank you for coming. Appreciate it. Casey, you can't unsee it. Once you see it. You might not see it at all. No, I'm telling you, not everybody saw it. But I did. I couldn't stop it. It didn't stop. It just kept going on and on and on. I couldn't stop it. No, Victoria has not joined yet, Fletcher. Thank you, Tokyo. 3. It's the first clip. Whew. But it's like 22 minutes long, so it's 22 minutes of that. And I watched it the first time when I was recording it, and I lost it. And then I tried to edit it, and I lost it. I played it here, and I think I might have lost it. Whew. Linus, love, you need to get some sleep. You need to get some sleep. If you don't make it to Fleischer today, don't worry. Just don't worry. I'm worried that you're not getting enough sleep. Legal will be there all day. Say what's hunting for it. You might not even see it. You might. I can't with that guy, that face. You did? Oh, that's awesome. Okay. All right. Show off, overachiever. Dutch man. The Dutch know how to overachieve, guys. Yes, they do. Did you get that ankle monitor taken off yet, legal? Sleep is for the weak. I made that thumbnail today for Linus. And I couldn't stop laughing the whole time I was making the thumbnail, too. Yep. That's all I did today was laugh. That's it. That's all I did all day long. All right. Legal got the scram. I'll wear your scram for you for $50. But if you don't do what I say while I have it on, I'm drinking. Yeah, we do. Fozzie doesn't. Fozzie's a hater. All right, guys, I'm gonna try to get you know what? This is the perfect time. I have a sad video I'm gonna put out as a video. So I'm gonna do that now that I'm all giggly. And then get ready for Judge Fleischer's stream. I'll see almost most of you there. And for the rest of you, I'll see you tomorrow. Thank you so much for coming out. Mods, you're awesome. You're always awesome. You always do such a great job. Except for that one. I hope you guys have a great day. And I will see you tomorrow. Bye, guys.